beginning or a sort of an icebreaker that we need to do before every lecture. We've been 1.5 months. I believe the first lecture was on the 6th of June, if I'm not mistaken. And if I'm also not mistaken, that was your first lecture of the syllabus of the course. And now I'm sure you must have done quite a few of them. And I'm not sure. This morning, did you have a lecture this morning too, or this is the first lecture that you have?
Madam,
These
morning
lectures are at
session was for second year.
yeah,
Morning session was for second year.
yeah. Normally, that's what normally we have. The first years have their lectures at 10 o'clock in the morning, and the second years have at 2. There
Actually,
is the shift
that
that
risk management and marine insurance is only for that lecture. It is conducted in the morning, either
yeah,
even during the offline sessions also.
morning or
Yeah, it is reversed for one.
just that I'm worried about the post-noon sessions is because people must have all had your lunches, and now I don't know. Uh, and again, as we all know, we've seen law and how it is, and keeping you all awake for a long time may be a challenge, but let's see how we can do that. So we started off with the commercial and shipping law last time, and we saw the syllabus and we saw all of that, and we saw the contents, and we started with the law of contract. Now, as I said last time, I'm saying I have to repeat this again. This is a sort of a crash course because where we do in other MBA syllabus, this entire half of this, in fact, syllabus in 13 lectures, we are doing that only in 6 lectures. In fact, it is 5, but then we push for that 6th lecture, and the institute has so far been kind enough to allot that 6th lecture, but most of the time, but actually, as a rule, it's only 5 lectures. So 15 hours, and we have to complete all this. So it has to be taught in a pretty concise manner. So sometimes there is no time for us to actually sit and dwell upon every query, every small thing, questions, or every small doubts that you'll have. But yes, like I have told you all, you'll have my number. If there is any doubts, we can also speak outside the class. And since everything is for I don't know how long, but we can at least do that. So even if your queries are not answered, I'll try my level best to answer them as much as possible in the class. If you'll put it in the chat box and all, really, really impossible because we have to rush through the entire syllabus. And if I have to sit and start reading, and also what happens, it's physical. It becomes more when you raise your hands or something. I can understand. Here, every now and then and seeing if there are any queries in the process. Sometimes you tend to miss on certain things that are also written or mentioned in the chat box. I will ask you to excuse me for that. But yes, if any of your query remains unanswered, please feel free to ask me post the class. I have had people from your class, one person, in fact, so far, because we have really not started anything, and I was pretty having queries immediately in the first class itself. But yes, it was there, and so that may happen. So any of you all have WhatsApp later on, because I don't really I can only apologize and say that I may not be able to take all your queries in the class. Of course, what is there, what comes relevant and what comes time that we will certainly be taken care of, answered. But sometimes it becomes a hassle. Sometimes I feel that this is not directly related to the topic. It is so much that we have to finish that we cannot digress. So yes, we will do that. And also another thing, I would like to request all of you all, when you're posting your queries, let it be let it be our syllabus oriented. Let us not again, law is vast. You can ask me 1001 queries, okay? But if that is not related to our subject, and our more than our subject, even if it's not related to our topic, I may just not want to go out of my way and keep doing that, because I would rather spend my time answering queries that are relevant and entertaining people who come with you require some help, assuming that I'm from the law profession. That's a different story that can be addressed. But otherwise, just don't keep sort of spamming my WhatsApp also with 1001 queries, which may not really be pertaining. I think let us start with our topic. If I'm not mistaken, we had stopped at consideration, because I've made that note at that point of time, since I know and I understand that 1.5 years, month, it becomes a little difficult for us to, recollect we are doing. It's not that we did this one lecture on the 6th of June and then we have sat ideal. We're doing 1,000 other things. So it can just skip out of our minds. And that's the reason why I had made a note that we have finished with consideration. Okay, I will start sharing the screen now. So yes, we are still on the law of contract. We had spoken about the essentials of a valid contract in the last class. To be applicable to all commercial transactions, whether it is shipping or it is agriculture or it is manufacturing of some other products, or it is service, it is pharmaceutical, it is electronics, whatever industry. For everybody, this law of contract is going to be applicable when anybody is planning to enter into a contract with anyone. This law of contract is going to be applicable. So when you speak about a shipping industry, if you're speaking about shipbuilding, you're speaking about chartering, you're speaking about freight, you're speaking about what are the other things? You're speaking about, salvage services, you're speaking about towing, you're speaking about your, I spoke about shipbuilding, ship maintenance, you're speaking about insurance, various other things which are included in the shipping business. Okay. For all these things, when you are looking at entering into a contract, the law of contract is something that is going to be handy, and that is something that needs, if this law of contract is not applied while entering into a contract, then it can pose a problem and there could be a conflict. And when there is a conflict, we all know what happens. And of course, we are going to look at, what are these conflicts, and, all of that we'll be seeing further. But to start with, we had said essentials of a valid contract. So what are the essentials of a valid contract? essentials of a valid contract. Contract is equal to a valid proposal, which we have looked at. A valid acceptance. The parties must be competent to contract. The parties should have given consent with their free will. There has to be a lawful consideration. There has to be a lawful conditions are there. The contract is a valid contract. What is a valid contract? A valid contract is a contract which holds good in the eyes of the law. Okay, it holds good in the eyes of the law. So anything that comes out of this contract, so if there is any sort of conflict, if there is any sort of disagreement, if there is any sort of somebody is not adhering to the terms of the contract, in all those situations, if the contract is valid, that is, if it holds good, that the court can actually give to the parties. So that is what an essential contract is. We may not be giving examples over here every now and then of a ship. I may be giving examples of a dog and horse and car and all of that. But that is how typically law is taught, unfortunately or fortunately. Even if you look at big law books, you will find them using that language, and that's the for in your minds, you may perhaps interchange a car to the ship, and you can perhaps look at it that way. But in the real commercial terms, yes, all contracts that fall in the shipping purview, I spoke about all of them: chartering, your shipbuilding, ship maintenance, insurance, any funds that are required by a shipping company in order to buy a ship or hire a ship or whatever, your freight, and all those other things that your salvage operations, on the port there would be certain things that that would be required, and all the things wherever a contract has to be signed or entered into. Signed is a different story. Wherever a contract needs to be entered into, all the essentials of a valid contract that we have spoken over here will hold good. So there has to be a proposal, there has to be an acceptance. The parties who are entering into the contract should be competent, that is, they should be of sound mind. They should not be minors, they should not have any sort of court proceedings against them. The contract should be by free consent, free will. There should be a lawful consideration, lawful object. Not to that you're sending goods by cargo which are of illegal types or something like that. All these things, so object, that is whatever you're giving, and the agreement should not be void. Keeping this in mind, you have to enter into any shipping or whether. So now we have spoken acceptance and valid consideration. Okay. Now we have to do the rest of the things. Consideration and object, I said it's most of the time interchangeable. What is a consideration to me could be an object to you, and what's an object to you could be a consideration to me. So that is not void. So let us. I hope I am audible to everyone.
Yes, ma'am.
Yeah, I'm audible.
Yes, ma'am. Yes, ma'am.
Yes.
I don't know why I kept feeling that my voice is low. But good, if you can hear me, I'm really good. So, yes, you also saw types of contract. I'm not going to look at it. Can I request people to go on mute, please? Yeah, okay. So I don't want to look at B and C on the screen, but let us just one second quickly. I will look at A on the screen, and we spoke about on the basis of validity and enforceability. There's a valid contract, void contract, voidable contract, illegal contract, and unenforceable contract. We've spoken about all of this in details. Valid contract we saw just now. What is a valid contract? I just want to make a point about void contract and voidable contract. The rest of the things are all right. We've spoken. I just don't want to speak about them over and over again. But a void contract is contract that does not hold good in the eyes of law. And we're going to look at what are some of the void contracts, okay, that we're going to see later. And a voidable contract is a contract that can be avoided by one of the parties to the contract, okay. If there are 2 parties, 3 parties, 4 parties, these avoidable contracts are those kind of contracts which can be avoided by one party. So if one party says that, no, I don't want to go ahead with this contract, it becomes a voidable contract, okay. Now that is the difference between a valid, void, and a voidable contract. Illegal contracts are contracts for illegal substances and all those things, which will definitely the other things fine, you know, illegal, so that will not hold. A possibility. You know, I will give you that substance which is not really in existence. To party.
Excuse me, madam. This is Irfan from NMIS. I think there's some issue with the network on your side. Not able to hear properly. It's breaking in between, and even the video is gone. So can you please log off and re-log in for a while? Maybe it will resolve the issue.
Is this true with everyone, that you all cannot hear me and you all cannot see my video?
Ma'am, you are
No, ma'am.
audible,
Loud and
right?
clear,
But you are not visible. Not visible.
You're
Yeah,
audible
ma'am,
and
you are
visible.
audible, but there is
There is no.
a
You can.
pause.
Now you are visible. Now you are visible.
No. Forget me. Forget my face. I want to see. But I want to ask you all if my screen is visible or not. Forget the. Forget.
The PPT is visible. PPT is visible.
Visible.
Yes.
Forget about my face. We
Ma'am,
have.
your voice keeps cracking. It's lagging.
Yes, ma'am. Ma'am, your voice is breaking.
Okay.
Actually, madam, the video is required for the online recording.
I understand. I forgot that. But I forgot in the sense that somehow it got shut by mistake when I was sharing the screen. But what is more important is the screen. If the screen is not seen, then thoda sa problem.
It is visible. Right.
Visible, no? Because there are some people who are saying, ma'am, you are audible properly. And then there are some who are saying, we cannot hear you. So I am confused.
No,
Now
your
it's- now
voice
it's
was
good.
lagging little bit.
Now it's good, ma'am. Now it's good.
Good now? Okay. Sorry.
Okay,
So
please continue. Yes, ma'am.
you'll want me to go a little behind and speak again. So I was speaking about the A, that is on the basis of validity and enforceability, what the contracts, types of contracts. So I spoke about and how they are different from one another. Valid contract, we have just seen just now, all these things: a valid proposal, acceptance, competent parties, free consent, consideration, object, agreement, not void. These are the things which fall under the, if all this is there, then the contract is a valid contract. Okay. Agreements or contracts which do not hold good in the eyes of law are void contracts, and voidable contracts are those contracts which are which can be avoided by one party. Okay, that's what I said. And I think let us move quickly ahead because we really don't have the time. Proposal, acceptance, consideration is something that we had completed in the first class. And now we are going to come to free consent. Okay? So free consent, according to section 14, and I had told you all in the first class, it's and sections. Paper, and as long as I'm checking section, if I expect you to mention the section will be a part of the question. Okay, so just don't worry about that. Oh, if something happens to me and if I'm not alive and if somebody else has to check your papers, then, but even then I would say, sections do not really form, mugging the section does not really form a part of our learning here. Okay, so just don't worry about so many sections we have to learn. But yes, some definitions you definitely have to learn. You cannot do without learning some of the definitions. What happens is I very often tell my students, and of course I'm going to tell you also, that you don't have You have to understand when it happens that people own what they write. It not really coincide with what is expected. Or actually, please to know. All of us need to know by heart. So there would be a couple I would learn by heart. Okay, so let's look at free consent. According not hostile, coercion or fraud or mistake. Okay, consent is a free consent without anybody to give that consent, or without anybody cheating you to give that making a mistake, or without mentioned something to you. That is not something that is a free consent. A free consent is a it is without any of these. Now we are going to look at each. Okay, what is undue influence, what is fraud, mistake. All of this is going to be explained in detail. So let us have a look at that, and then we will understand what exactly is a free consent. Okay. So 13 of the Act describes coercion as, please go on mute, describes coercion as committing or threatening to commit any act forbidden by the law in the Indian Penal Code. Okay? That is coercion. And unlawfully detaining or threatening to detain any property with the intention of causing any.
We also need refer to IPC, or should also have some knowledge about.
Not necessarily you have to refer to ICC every now and then. Only what yes, or certain acts that have been committed which are not in our purview at the moment. So that those could be perhaps looked at from the Indian Penal Code point of view, but not in that every now and then you have to sit and refer to the Indian Penal Code. So coercion, basically committing or threatening to commit any act forbidden by the law. So anything, for example, if somebody is keeping a gun on your head and saying that please sign, that will amount to coercion. Anybody threatening you to rob you of something that and making you enter into a contract. That will coercion. When you have to remember all these things, the 5 things, because this very often is a question for you in the examination. Against coercion, you can write coercion. That is basically coercion. So if somebody threatens someone and makes that person sign the contract, basically free will, no? Free, but that person has, if somebody is holding my child and sends contract, sign on this contract, otherwise we'll shoot your child, I will definitely want to. I will contract, but it was not with my. Any act by which there's a threatening, and because of that threat, if somebody contract, because it is not given by a free consent. Okay, so that is what coercion is. The next is undue influence. So all these are section 4. It starts from section 14, where they have explained free consent. So what is free consent? So free consent is a consent which is not caused by coercion, undue, explaining each of these in detail. Of course, we're not going to go into complete details of that, but yes, at least actually mean. Okay. So undue influence. Section 16 of the Act contains the definition that when the relations between the two parties are such that one party is in a position to dominate the other party and uses for unfair advantage of the other party. Okay, so when there is a pressure, there's a pressure because of relationships. So, in a relationship between maybe a student and the teacher wants the student to do some act which the student would have otherwise not done, but because of pressure, perhaps of the marks, the student is willing to, enter into some contract. And that is again not a contract with free consent, because that has been done because of the pressure that has been exerted by the teacher who's in the dominant position on the student. And also further beauty in the following, or even with the other person. Fiduciary is financial relationships. Okay? He makes a contract with a person whose mental capacity is affected by age. The unsoundness of mind can be temporary or permanent. So there are two kinds of relationships that I have explained over here. One is an apparent authority. That's what I said. Maybe a teacher and a student, or maybe a boss and the employee, or also could be a landlord and a person who's on rent. That person is helpless and at the moment cannot really think of entering into any other premises or this position over there, or with one another. Somebody's holding someone's money, interest money. So in these kind of exert that kind of make a person sign the contract, and this was affected by a grandmother. The grandson, typical example that is given in all books, and a grandson is looking after this old grandmother. The grandmother is now aged and dependent on this grandson, and this grandson will force this grandmother to sort of, by sort of exerting that kind of a relationship and saying, by mentally influencing this lady and making her sign the agreement. So that is this. When this happens, it becomes, when one party is in the position to dominate the other party, such influence to obtain an unfair advantage of the other party is said to be undue influence. Okay, so we spoke about coercion, we spoke about undue influence. Let us go ahead and speak about fraud. Yes, again, there was this gentleman at Indian Penal Code. There are certain things, certain acts which would fall under, which could also fall under criminal activities. So, like if you look at, later on, I don't know whether you may be from the shipping back, maybe industry and the knowledge. But if you have heard of piracy, criminal activity, and then would be the law of the country, the criminal law of the country in whose boundaries the ship was at the time that piracy happened, or it could be the flag in those countries, whatever criminal laws were applicable. Based on that, perhaps the proceedings will happen. But yes, this is commercial law on Indian Penal Code. I I have mentioned this. I don't know if I have said this in the last class, but if I have not said this in the last class, I would like to say it just now, because I say this in all my law classes, that ultimately when you look at any matter, you have to look at from a very old learning correlation. In the courts, look at particular substance of the matter with regards to the man, where it look at, they're going to look at the matter, because it may, like I said, in the undue influence on the grandmother to sign the property. Now, which property was, so go in, on your, it could go on or it could also be the transfer of property law are looked at. If there is a matter in the court, there are different acts and different sections of different acts that become applicable to that particular matter. Okay, so when I am saying that when we are learning the commercial law or business law, as it is called in management parlance, it does not mean that business law will not have any implications of any other laws that are there. Okay, that are existing, that are codified. So a matter has to always be looked at in a holistic way. But yes, some of the cases will have some of the concepts will have direct association with other kind of. So when we speak about labor, when we speak about commercial law is basically a civil law. But some of these aspects, like we spoke about coercion, or now we're going to speak about fraud. That has to be looked at from that perspective. But while studying for examination or for studying as a subject, you don't have to refer to the Indian Penal Code and go, what is the definition of coercion, or what is, or what are the implications and what are the case laws and all. That's not really required. Okay. Let us go back to fraud. So like, fraud, we're speaking over here, you will see that fraud is also defined by the Indian Penal Code under section 421. 420 is cheating. We say, no, 420 aadmi hai. What do you mean by 420? 420 is cheating, and fraud is section 421. So what is fraud? Fraud means decide when one of the parties deliberately makes false statement. I know that something is not right. I know that something is not true, and I'm making that statement, and somebody is relying on the statement of mine and entering into an agreement. That is fraud. When I'm
excuse me, madam. Fraud and scam is similar.
Yeah.
Fraud and scam is similar.
Part of this scam, if it fits into this definition, then it will be similar. I would request you all to please put your questions in the chat. So. So if if the scam that you're speaking about fits into this category, then it will definitely be a fraud. Okay. So according to section 17, a fraud is when a party convinces another to enter into an agreement by making statements that are suggesting a fact that is not true, and he does not believe it to be true. Okay. A person is making a statement. I will sell you my ship for 20 crores. Okay. He knows that in the where he can actually sell it, it is not asset that is there. But if he is trying to project, he believes, he knows that a ship is not in a functional condition, but he makes that statement and he says that I will sell active concealment of facts, or not revealing that it is not functional. I'm willing to sell it to you for 20 crores, but you will have to put another 20 crores and make it functional. When somebody is not making that revelation intentionally, then that is fraud. A promise made without any intention of performing it. Okay, I will sell you my ship, but you really don't want to sell that ship. A promise made without an intention of performing it. And any other act that is fitted to deceive, that is to cheat. So any other act that is fitted to cheat, to deceive a person, will fall under the category of fraud. So fraud is basically a type of cheating, and yes, it could be black marketing, it could be, I don't know what is your definition. Concealment of fact, like I said, you are selling you want to sell a car. Very simple example. You want to sell a car, and telling the person that the tires of the car are not in working conditions. So whenever you buy the car, you'll have to first change the tires. You know that the tires are not good. Okay. Now, of course, yes, the person may come, look at the car, and then buy the car. But what if you are in Pune and the car is in Bangalore and there is no time, and you have seen the car about 4 months back or so, and you like the car, and from that point you have decided that yes, I want to buy that car, and within this 4 months the tires have gone bad because of whatever reasons, and now you want to buy a car from the owner who's sitting in Bangalore, you're in Pune, you have seen the car 4 months back. So you are saying that I want to sell the car, I want to buy that car because that person has made a proposal that I want to sell it. Will you be willing to buy it? You've seen my car 4 months back, but within the 4 months, and then you're paying a particular price, and this person is not telling you that the tires have now gone bad, and you will have to fit the tires, complete new tires to the car. That is concealment of fact. Have I answered your question, Mr. Tiwari?
Yes, ma'am. Thank you.
That is concealment of fact, and that happens, very often. Now, when we are going to do misrepresentation, that is the time, perhaps, we will understand the difference between the fraud, between, concealment of these facts. So, in fraud, when we are speaking about fraud, no, these things are done in. Cheating, sorry for the Hindi in between. Sometimes it just comes out. But yes, I understand the language. So my apologies. So, when we speak about fraud is done with an intent, very clear in mind. It has not happened by mistake. It has not happened by innocence. It has been done with the intention to cheat. If it is not done with the intention to cheat, it will not be fraud. Okay. So when we speak about the word scam, now, for defined in any law, I have really not come across the definition of scam. But yes, colloquially or in local language, what is fraud? Someone, scam is done with an intention to cheat someone. It will definitely fall under the category of fraud.
A scam may involve multiple. A scam may involve multiple persons, more than one. A fraud may be committed by a single person.
It can involve fraud can also involve multiple persons. Scam may also involve several people. So because honestly speaking, I have yet to come across a definition of scam. So according to me, scam is just one of the words used for the multiple kind of frauds that people commit or people do. But whatever it is, we are not to discuss scam. We are here to discuss fraud. And so fraud is something which is done. So anything, whether you call it scam, you call it black marketing, you call it cheating, you call it, you give it any other name, whatever it is, but if it is done with an intention to deceive someone, with an intention to cheat someone, it will fall under the category of fraud. And agreements that are entered into by doing this kind of frauds are not a valid agreement, because they are not agreements that have been given by free consent. Sanjeev, right? Sanjeev, you asked about concealment. So I gave you this example of this car and the tires. Okay.
Yes, ma'am.
You have to buy this car with, tires have gone wrong. Would you really want to give, just hypothetically? Okay, we're speaking all this hypothetically. Would you really want to buy the car for that price? But you would have said, yeah, Mereko, I have to spend some 40,000 on the tires now. If I have to spend 40,000 on the tire, I will not. So 2.10 lakhs. Correct.
Yes, ma'am.
That is how we think about. Correct. But if we are not told, then we will say, okay, 2.5 lakhs seems to be a good price. I wouldn't have got a better car than this. So you have given your consent for that 2.5 lakhs because the fact was not to you, the fact was concealed to pay 2.5 lakhs or 2.50 lakhs. But now that you know that this fact was concealed, you will say that no, I had never agreed to buy a car which kind of an agreement will then become an agreement which is not with free consent. Okay, let's quickly move ahead. Fraud. Here comes misrepresentation. Very, very similar to fraud. Very similar to fraud. But misrepresentation is done innocently when a person doesn't know. Okay, so the person who is selling his car is sitting in Delhi. Sanjeev, you're in Pune, hypothetically, okay? That the owner of the car is sitting in Delhi, you are in Pune, and the car is in Bangalore, where the family of the owner of the car is there, and they're not really so much, they don't have that much knowledge about what the tires and how tires and what kind of this thing and all that. You have seen the car 4 months back when your friend had come from Delhi and he had driven the car from Bangalore to Pune and all of that. You all had good time. You had really liked the car. When he was going back, he had mentioned to you that I will be selling off this car very soon because I want to buy another car. Okay. And from that point, you had it in mind, and perhaps at that point of time, you had said to him that, yes, whenever you plan to sell this car, just let me know once. I may want to buy it. And then your friend is in Delhi now. The car has been lying in his Bangalore house. It is unused, and over the period, the tires have, there's a wear and tear, and he also doesn't know, you also don't know, and you have agreed to sort of, buy a car, you have transferred the money to him, and now you go to take the delivery of the car to Bangalore, and that's the time you realize that the tires have gone bad. Okay, but here, the intention of the party was not to create,
reveal the facts.
It was not to conceal the facts. It was not to give you inaccurate information. It was not to make false representation, but it was just a misrepresentation of what happened. Okay, so that is the difference between fraud and misrepresentation. Same case, but fraud with an intention to cheat. If I'm getting more money from him, why should I conceal the fact to him? Let me take the money from him. That was cheating. Here, it is not cheating. This poor person had no knowledge that this has happened in the past 4 months to the company. Okay, so misrepresentation is also when a party makes a representation that is false, inaccurate, incorrect, etc. The difference here is the misrepresentation is innocent, that is not intentional. The party making the statement believes it to be true. Misrepresentation can be of 3 types. We'll see that. Okay, so again, Prince. So when we are writing, coercion is threatening, undue influence is relationship pressures or dominance of the relationship. Fraud is cheating. Misrepresentation is innocent representation, innocently making false representation. So remember these things from this perspective. You will be able to frame your answer and write your answer in the best possible manner. Okay. Let us look at what are the 3 different types of misrepresentations. a person makes a positive assertion, believing it to be true. Arey, gaadi to first class condition mein hai. The car is in the best condition. Yeah, you had seen it, na? 4 months back, I had got it from Bangalore to Pune. It was all right. Yeah, fantastic. Okay, positive assertion, believing it to be true. Okay. Any breach of duty gives the person committing it an advantage by misleading another. But the breach of duty is without any intent to deceive. Okay. Your car will reach you in 4 days. I've asked my driver to come and drop the car at your place. But the person was not aware that now there is going to be a lockdown that will be announced and borders will be closed. Okay. So the duty of sending the car in 4 days have now 6 months have passed. But what could be done? It was not to mislead someone, but it was because it was not possible to do it. Okay? And when one party causes the other party to make a mistake as to the subject matter of the contract, but this is done innocently and not intentionally, causes the other party to make a mistake at the subject matter of the contract. Same thing that we spoke about. It makes you enter into a contract, which was by mistake. He had no idea about the tire, the subject matter of the contract. Of course, when you speak about the car, it is a holistic thing. You will not speak about the steering and the engine and the battery and the other things separately. Okay, tire, at least it's a visible thing. Sometimes battery is such a thing which you take your car out and then after a while, it goes a little bit and then after a while it just gets, you drive for an hour or so and then it just gets stuck. And then you realize that the car is not moving and it is not starting. And what has happened? So battery has gone bad. These are some of the things that happen. Similarly, try to correlate or bring more examples from the shipping industry. If any of y'all want to give any examples from the shipping industry, or please put them in the chat. I will be glad to read them out to the class. Okay, a representation is a statement of fact or opinion which is made prior to the contract being entered. It could be of the fact or it could be of the opinion. Now, fact, if it is a fact, so when we are speaking about the tires of the car, it's the tires of the car are there. Or when we are speaking about the battery. So you're making a representation about a fact that there's a battery, but the battery, you are not aware that it is drained and it has got completely bad and it needs to be changed. It cannot be recharged. Okay, so that is there. So it could be, sometimes it could be, the representation could be, okay, we are getting some shipping examples also. I'm happy to see them. More examples also welcome. So it could be, so representation can be a mistake of fact, or it could sometimes be a mistake of opinion also. That has happened. Okay? But typically, it is about the subject matter. If you look at the definition very clearly, it is about the subject matter. So most of the times it will be about the misrepresentation about the facts that is made. Okay. Yes. So we have some example. Difference in the bunker quality, certificate and test results. Okay. The owner knowingly declared wrong dates of vessel arrival to the charterers. Knowingly wrong bunker consumption declared to charterers. Yes, these are some of the things. No, but when you say knowingly, when you say knowingly, what it amounts to? When you say knowingly, what will it amount to?
Fraud.
Yes, right? It will amount to fraud. Okay. Unknowingly, when it is done, then it will amount to misrepresentations. Okay. So sometimes it could be, some of these things could also be, misrepresentations that are done. Probably the charterer is now. Give me an example of misrepresentation. And the same thing, wrong dates. How could it be misrepresented? How could the wrong date of vessel arrival be
when the vessel is declared for the same date, but due to bad weather, vessel arrived late.
Okay, that could be misrepresentation. What else? That is actually, force merger, what you say, it is beyond the controls of anyone. it actually gets into that. But wrong BL quantity provided to port. Now this wrong BL quantity provided to port was intentionally or unintentionally. You have to look at that. Okay. So I think you all have got the gist of it. You just have to distinguish between fraud and misrepresentation. It has to be fraud has to be with an intention to cheat, and misrepresentation has to be which is done innocently. So probably a charterer has has chartered a ship, a vessel from the owner, and the owner has perhaps told the charterer that it has the capacity of sailing so many nautical miles in a particular in an hour or something like that, and based on that the charterer has estimated the time for it to arrive, the vessel to reach the port. A date has been given, but unfortunately the capacity or the engine, the speed of the engine of the vessel may not really be that. Could be much lesser. So this charterer, when the charterer has given this date, it was not done intentionally. It was done because that charterer himself was not really aware of what is the actual speed of the running of the vessel. Okay. So these are some of the things that fall under misrepresentation and fraud. Last but not the least, consent is not free if it is obtained because of mistake. What is mistake? Mistake is an incorrect belief about something. The belief is incorrect. Okay? It is an erroneous belief concerning something. Now, mistake and misrepresentation, somewhere they are very close to one another. Okay, they're very close to one another. And sometimes, if you look at it, you may also, in certain things, they may also be used interchangeably. People may use it interchangeably. Instead of saying it was a misrepresentation, people may say mistake happened. Okay, because it's an erroneous belief concerning something. It could be stated as an error of judgment. So now mistake is of two types. Mistake can be of law and mistake can be of facts. Okay. Now when it comes to law, when it is the law of your own country, you are supposed to know the law of your country very well, and you cannot say that mistake ho gaya. Okay. If you break the signal and if you say that, oh, I didn't know that red signal stands for, this thing, or no entry, okay, no entry tha, I didn't know, and I didn't see the board and all, or whatever. But if it is a mistake, and you will have to then sort of pay for it, correct? People are not going to treat you with sympathy, saying that acha jane de bicharo ko malum nahi. Poor guy did not have the knowledge about it. Okay, but when it comes to mistake of law of a foreign country, it is treated as a mistake of fact and not of law. Okay? Now, mistake of fact, when we speak of, there's a bilateral mistake. That is, mistake is done by both the parties. There was a
आपण संध्याकाळी भेटणार आहे.
When we speak of mistake of fact, there's a bilateral mistake. That is, mistake done by both the parties. Okay, on a particular thing, there's a mistake that was done by both the parties, and there's a unilateral mistake. That is, mistake is done by one party. The other party had no idea of this mistake, but and had believed that it would be right. But from one party, the mistake has happened. Now, basically, why are we looking at all of these mistakes and misrepresentation and fraud and coercion and undue influence and all of that? We're looking at all of this to understand whether these agreements that are entered into by coercion, agreements that are entered into by undue influence, agreements that are entered into by fraud, by misrepresentation and mistake, are these agreements valid agreements, void agreements, or voidable agreements? Now, we have already seen in a valid agreement, an agreement has to be with a free consent. Correct? Now, when we are speaking about agreements that are influenced by coercion, undue influence, fraud, misrepresentation, and mistake, these are not agreements that are agreements made by free consent. So, definitely, such agreements are not valid agreements. Correct? So if they are not valid agreements, then they have to be either void agreements or voidable agreements. Correct? So what are these agreements? So when you look at coercion, undue influence, fraud, misrepresentation, all these 4 categories of agreements are voidable agreements. They can be avoided by one party. Okay? And if one party avoids it, then they will become void. Okay? If none of the parties avoid it, they want to go ahead. Okay, coercion to coercion, I want to enter into this agreement. I have now signed the document, whether it was because of threat or whatever. I want to now enter into the agreement. I don't want this man to again come and say that I will shoot your child. Correct. So I don't want to avoid the agreement. So these agreements, even if it's undue influence, or it is fraud, or it is misrepresentation, all these agreements are voidable agreements, where if one party takes a stand that no, I don't want to, this agreement is not a valid agreement because I had not signed it with my free consent, but I had signed it because I was forced to sign it, or I was misrepresented, I was cheated, then the agreement will become void. Till then, the agreement will be a valid agreement. Okay. But when you speak of mistake, when it is of the law of the country, illegal goods, you're not supposed to sell illegal goods. You're not supposed to sell goods that are what is that? That you have acquired by fraud or cheating. You have a stolen car, and the stolen car you want to sell it to somebody. Okay. And this somebody is entering into the agreement not knowing that it was a stolen car or something like that, and then but it is not it cannot be a valid agreement at all. It's this kind of an agreement, when it is by mistake of law, this kind of an agreement has to be a void agreement. Certain pharmaceutical products, if you cannot sell them without a particular license, and if somebody has sold them without a particular license, the agreement or the contract, this kind of a contract will be the contract for selling those products will be a void contract. Okay, people have not known. Both the parties who have sold the contract and who have again taken sold those pharmaceutical products and who have bought those pharmaceutical products were clueless that there has to be this particular license that has to be given by the authority to the seller and the buyer to enter into this contract. These things can happen, right? And but the sale has already taken place, but the contract will be a void contract. It cannot be a voidable contract. Okay? Unilateral mistake, which are not of the mistake of law of the own country, which is only a mistake of fact, and if it's a bilateral mistake, then the agreement is void. Like I said, exactly this thing, also. A bilateral lateral mistake of fact is also the fact is that there is no proper license, and without a license they have actually sold these goods. And if they have sold these goods, both the sides were not aware, parties were not aware that this license should have been there. So it's also a matter of fact actually that it was not there. Bilateral mistake, when a mistake has happened from both the sides, the agreement will not hold good in the eyes of law. But if it is a unilateral mistake, a mistake has happened only from one person, but the other person is okay, even if that mistake has happened, he's okay. So these pharmaceutical goods were sold, and this person says that he then realizes that okay, this was there. The other party tells him that, but where is the license? And that person says, okay, wait, I will obtain the license and bring the license, and he gets the license in that prescribed period of time. Then it is on the buyer whether he wants to treat this agreement as void or voidable. This agreement can be avoidable agreement also. It is not, contract is not voidable, contract can be voidable. So this was about free consent. According to section 14, consent is said to be free when it is not caused by coercion. Coercion is equal to threat. Undue influence is equal to influence of the relationship. Dominant position in relationship. Fraud is cheating. Misrepresentation is representing something innocently. And mistake is not knowingly doing something. Again, a sort of an innocent misrepresentation. So in case of coercion, undue influence, misrepresentation, and fraud, the contract can be avoidable contract. In case of mistake of law, the contract will be a void contract. Please, can you please go on mute? Can you please go on mute?
How do you do it? Resolve.
Allah, can you please go on mute? So it could be a mistake. So this is free consent. Going back to our definition of a valid contract. So we have spoken about proposal, we have spoken about acceptance, we have spoken about consideration and object, which goes hand in hand. We've spoken about free consent. We have to still speak about competent parties and agreement, not void. Agreement should not be void to be a valid contract, right? So capacity of contract. According to section 11, every person is competent to contract who is of the age of majority according to the law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is a subject matter. To put it very simply, in India, the person has to be 18 years and above in order to enter into a contract. He should not be insane or should not have any mental challenges when he's making the contract. Sometimes there's a possibility that a person is not mentally challenged all throughout. Okay, there are bouts of this mental challenge issues that a person faces. So for that particular kind of a person, if that agreement is signed in the situation in which he was of a sound mind, then that agreement will be a valid agreement. If not, if it was signed when he was of the unsound mind and he was then made to sign that agreement, like we saw, then it could be undue influence and it could be a avoidable agreement, but otherwise it can be a valid agreement and not qualified from entering into a contract by any law that he is subject to. If the person is not qualified into entering into a contract because he has some legal proceedings against him or any other matter, the law has forbidden him from entering into a contract. Then anybody from these three categories, if a person has entered into a contract, that particular contract is void ab initio. What do you mean by void ab initio? Word void ab initio means that the contract, it is assumed that this contract never came into existence. Okay, it was never there. It is signed by somebody who is not 18 years old. The contract has, even if it was signed and physically there, it will be assumed that this contract was never ever. This contract has never ever happened. If it is signed by somebody of an unsound, who is of an unsound mind, who's perpetually of an unsound mind, or who is of an unsound mind at that particular point of time when the agreement was entered into, then that agreement will be assumed that agreement was never done. Or if it was entered into somebody who was disqualified from entering into a contract, was debarred or anything like that, then again that will be a contract which had never come into existence. Although it was there physically, but it will be assumed that it has never come into existence. Okay. So here we have already seen that all these three cases, if a person is a minor, person is not of sound mind, and a person is disqualified from entering into a contract, then in that situation, the contract is a void contract. Correct? So the contract is a contract which does not stand good in the eyes of law, and it is a void contract. Let us look at some other contracts which are void contracts and which do not hold good in the eyes of law. So minor, unlawful or unsound mind, and consideration or objective or object as unlawful. Okay, the consideration that was given, the car, the vessel, the pirates had what they had done. They had confiscated the vessel, and now they're going and selling it to someone. What is not yours, you cannot really sell, right? So the object, that is the vessel, was of an unsound, was of an unlawful nature. It was of an unlawful nature, and therefore entering into a contract for this unlawful thing will not be a void agreement. Okay. Agreements induced by mistake, we saw. If it's a mistake of law and both the parties have made this mistake, then it will be a void agreement. Agreement and restraint of marriage. Somebody asking someone, marriage, we'll also see the other three things: in restraint of marriage, in restraint of trade, and in restraint of legal proceedings. All these three cases, marriage is a right of a person, trade is a right of a person unless they're doing unlawful trading, but legal lawful trading is a right of a person. To enter into a legal proceedings is a right of a person. All these three are rights of a person. And if somebody is entering into an agreement or a contract to restrain to this, I will give you 20 lakhs rupees if you do not get married. Okay, then that agreement is, or that contract is a void contract. This person who goes to the court saying that he was going to give me 20 lakhs of rupees will also not hold a good standing in the court, because the court will say the contract itself was a void contract. This kind of a contract doesn't hold good in the eyes of law. So, or if the person says, I had told him or her that I would give 20 lakhs rupees, I'm ready to give 20 lakhs rupees, here I have, or this person has already taken 20 lakhs of rupees from me and now got married. Court will say, but who asked you to enter into this agreement? Because this kind of an agreement it does not hold good in the eyes of law. You cannot get any remedy out of that agreement. When you speak about void agreements, it basically says that you cannot get any remedy out of that agreement. Okay, we are going to see what remedies are, but you cannot get any sort of, the court cannot give you any sort of relief in these kind of agreements. So, agreement and restraint of marriage, agreement and restraint of trade, agreement and restraint of legal proceedings are three such kind of agreements which do not hold good in the eyes of law, and nobody can get a remedy from these three types of agreement. You do not enter into trade with this particular party and I will give you money. You have given him money, but that guy has gone and entered into trade. You cannot go and tell the court that I have given him money. I told him not to enter into trade, this, that, and that. Similarly, legal proceedings. Okay. Uncertain agreements. Agreements for which there is no certainty of happening. Okay. Those agreements are also void agreements. I am making this land, I will give you this particular land if if your first child is a male child. Okay. Uncertain, right? You never know what would your first child, what your fifth, sixth, seventh child also may not be a male child. There's so much of uncertainty. And then that person is giving certain piece of land already even before the event has happened. And the remaining I will give you when the child is born, when the male child is born. And then you go to the court, this person goes to the court saying that I have already given him this much portion of land, and now, this agreement is a void agreement itself. This agreement does not hold good. It will not go, that land land, that portion of land will not be transferred itself. So we won't get any relief from these kind of agreements. Wagering agreements. Wagering agreements are basically speculations, bets, lotteries and all those kind of things. They fall under these wagering agreements. Again, they are all void agreements. There's no relief in the court. If you take that agreement, you fight for that agreement, they're all agreements which do not hold good in the eyes of law. Agreement to do impossible or illegal acts. They are different, okay? Impossible and illegal are two different kind of acts. Impossible acts are, to give you the most, may sound very silly, but the silliest example is to get the stars from the sky, plug the stars from the sky. That is impossible. And there are some impossible possible things that happen in trade also, in trade also, in commercial transactions also, things, it's impossible for that thing to happen, but still we want, we want that thing. I will buy you 100 typewriters, which are freshly manufactured. Everybody has almost shut down the typewriting business. If it is something that is impossible to get a typewriter today, which will be of the latest make and latest type. That could be something like an impossible thing happening now. Of course, until 15, 20 years back, it was in thing, or even more than that, even less than that. But today, if you have to actually go and find out. And so many things, if you can correlate it with your shipping industry also, there could be so many things. It's still possible to find, certain things, impossible acts. Okay. And illegal acts. Now, illegal acts are what? Acts which are not legal in the eyes of law. Like I said, there are some illegal acts. If the act was not illegal, the agreement could have been a valid agreement. Selling of pirated ship which does not belong to you. Okay? Otherwise, if these pirates enter into the agreement, everything else, proposal, we are selling the ship, there's a valid acceptance, there's a consideration that is given, there's an object that is there, free consent is there, everything is there. Everything is in place. Only what is not in place is the ship is not, it's an illegal ship because it was pirated, it was robbed, it was stolen by the people. So agreements to do an impossible thing, an illegal thing is a void agreement. It will not hold good in the eyes of law. With that, we complete speaking about what is a valid agreement or a valid contract. Let us call it a contract. Okay? A valid contract is a contract which has a valid proposal, a valid acceptance. The parties are competent to enter into contract. The consent is done. The consent which is given to enter into the contract is a free consent. There is a legal consideration and a legal object. Okay, and the agreement or the contract is not a void contract. These are the essentials of a valid contract. I am repeating this over and over and over again because there's a possibility that you may have this as a 20 marks question in your paper. Possibility. I'm not saying it will be there, but there's a possibility. So we have seen all these 1, 2, 3, 4, 5, 6, 7. Now, let us go on or move on to the next topic, and that is discharge of a contract. A contract is deemed to be discharged. That is, it is concluded or no longer bounding in the following circumstances. So what is the discharge of a contract? Discharge of contract is a contract which is concluded and which is not binding on the parties anymore. Okay. Now, how does that happen? How is a contract discharged? A contract is discharged by performance. I was, okay. You had asked me, we had entered into a contract ship, okay. Terms and conditions you want, the make of the what were the things that you wanted in the tonnage, the speed of the engine, all that was done. You had decided as advance amount. Please go on mute. So you had decided, we had decided, there was a contract between my company and your company that you will pay us advance amount, and then as the ship was getting progress, as the building was getting progress, you were supposed to pay me installments, and then there was some retention amount that was there that you were going to keep for 1 year in order to see that everything in the ship is all right after the ship does its first vessel, and after observing that everything internally is all okay, then you were going to release that that amount and all that. It happens, all these things happen, correct, in shipbuilding industry or any other industry. These are the things that happen. Now all this has taken place. Your company has discharged your obligations. So the entire transaction is a done deal now, which means your obligation and has come to an end, or it is a concluded contract. Discharge of contract by substituted of that. In this, there are about 4 different kinds of things that are there. One is novation. That is, there is a contract. There is a new clause that has been added in the contract. So a charterer has taken a vessel from the owner in order to sail, and then the charterer and there was a contract that was entered into and all that, and it is the contract has started. Everybody is doing their own obligations, and now the owner of the contract wants to add a clause there saying that this particular vessel will not BCD ports. The vessel will we do not give you the permission to sell it to these particular ports. This is something new that has been inserted in the contract. Now the charterer may be having their major business in on these particular ports. Why would the charterer with this contract want to discharge or conclude? Want to keep your ship on charter, your vessel on charter.
And this condition arises in the midst, says that port B or C. It arises
of the journey, but it can, because if it's a time charter and has been for 5 years span, no, it may not arise in the middle of the journey. It cannot arise, and even if it arises in the middle of the journey, then not just the law of contract, there will be other laws also that would have an implication, correct? Like your other things, your your bills of that, or any other, your Indian Indian Paksa, and all of those also will definitely play a role in this kind of a transaction then. But then if the ship is on the port, it is not sailing, and then if somebody comes, these are just hypothetical cases, but these can happen. So if this happens, and it would definitely be at the privilege, or then whether he wants to take the ship or not. If it happens in the middle of the journey, it can happen in the middle of the journey also. But in the middle of the journey, then the charterer will have to definitely complete his voyage Correct? You cannot just for the owner at that point of time. The obligation of the charterer would be more towards the customers whom he have to please. Maybe if it's a passenger voyage, then it's a passenger so he has to please, or he has an obligation towards. Or if it's a cargo, he will have to, he has an obligation towards the consignors and the consignees. Correct?
So this is known as novation, that the entry of this new clause. This is known as novation.
So novation is anything, not just this. This is just an example. Novation is a small thing also. The party, the person who has the other party, and it can be from anybody. Buyer and you're the seller. It could be seller, or it could be from the buyer. It could be from anyone. Any agreement put in the agreement, the other party has the right to say that I want to conclude the agreement. It's not at all acceptable to me. Why would you enter into? Why would you still remain into a contract if that new clause is not acceptable to you? You may not want to. Similar cases with the alteration of the contract clause. Now, when you say novation, it's a completely new clause. Alteration is a clause which is already there and saying that we had given you the ship on charter for 5 years. Now, instead of 5 years, we are making it 3 years. Or we had said that, you will pay us a rent of rupees so and so, and there will be a hike in rent by 15% every year. And now you're saying I'm altering the clause to not 15%. The hike of rent will be 30%. He will say the hike of rent is 16%. That is also may not be acceptable to you. Why would you want to enter into, still remain into the contract? It's not bind on me because I had never agreed for this initially.
Ma'am, I just wanted to give an example on this. I mean, suppose if we have a geared ship with 4 cranes, and one crane.
I cannot hear you. I can't hear you. Yes.
Can you hear me now?
Be a little more loud, please.
Okay, now you can hear me?
Yes.
Okay, if a ship is having 4 cranes and charterer has taken this ship for a geared trade, and if one crane doesn't work in between, I mean, if one crane has a problem and now owner wants to change this contract to a ship on charter with 3 cranes, so this is a novation or alteration. Is it a new clause being fitted or just? I
think if the both parties agree, then.
What's this? Who had asked me the question initially?
Me, sir. Me, ma'am. Jwalant.
Alant. What do you think? What would it be?
No, I actually had a doubt, so that's why I asked.
You had a doubt? Okay. Anybody else wants to answer this?
Alteration. It will be alteration.
Alteration. It will be an alteration.
Yeah, looks like alteration.
Yes. Alteration, madam.
If both parties agree, then it will be alteration. After acceptance by both parties, then it can be called as alteration.
No, there is a small change in the contract, right? They are not changing complete contract.
No.
So any party can discharge this contract due to alteration.
Yes, it is not after acceptation. After acceptation, there cannot be a discharge of contract. So get that very clear first. If there is a novation, if there's a new clause insert, if there is an alteration clause that is going to be done, the parties have, and the party has already accepted the new clause, the party has accepted the alteration clause, then the contract cannot be discharged. There's a new clause that is inserted, there's an alteration that is made to the clause, and then it is taken to another party to say that, now enter into a contract with this new clause and this thing, they can discharge the old contract. Okay, so it is not that if it is accepted, it becomes alteration, and if it is, if it is not accepted, it is novation. It is not like that. It is about a new clause getting inserted altogether, or it is about a clause which is already there getting altered. Are you all getting the difference?
Yes, ma'am. Yes.
Okay.
Got it, ma'am.
It is not about, it is not that, okay, new clause laga diya hai, and now, okay, the parties have agreed to the new clause. So now this agreement is altered. Yes, the agreement is altered because there's a new clause, but they're two separate things. Putting a new clause in an agreement also needs confirmation from all the parties to the agreement. Parties to the agreement may not be two. There could be 10 parties to the agreement. All 10 parties have to agree to this agreement, to this new clause that is put. All 10 parties have to agree to the alteration clause that is put. So these are two different clauses, okay? Different ways of putting clauses. Novation is a complete new clause inserted. And alteration is an alteration made to the clause. Okay, the clause is already there. 5 years ki jagah, now you're saying 3 years. 15% ki jagah, now you're saying 17%.
Ma'am, an alteration can be done only by acceptance after both the parties. Then only an alteration can be made after acceptance.
Even novation. If the parties don't consent, what will happen? The agreement or the contract will be concluded. The parties will not be bound on that particular agreement.
Yeah.
Understanding? If there's a new clause that is inserted between you and me, there is an agreement. Very simple agreement of buying and selling certain things. Okay. Now we have entered into an agreement. I am an oil merchant, and you have entered into a contract with me that every month I will be selling you 100 tons of oil. Okay, this is an agreement between you and me. Very, very simply, let us put. Okay. Now I'm altering the terms to, because I can see that I cannot really provide you with 100 tons of oil, and I'm making an alteration saying that I will provide you with 50 tons of oil. Now that 50 tons of oil may not be enough for you, no. And when I'm selling you that 100 tons of oil, what happens is when I'm selling you in bulk, the rate goes down. If you have to take from me 50 tons, okay, I will keep the rate for 50 tons the same, because perhaps I'm not in the position to sell you 100 tons. But somebody else from whom you need that 50 tons, he's going to give you at a higher price if you're buying only 50 tons. So what would you want to do? You may not want to continue with this kind of an agreement, correct? You will say this alteration is not acceptable to me. I'm concluding the agreement, and now this agreement is no longer binding. In the next month, if he doesn't, if you don't buy from me, even if I go to the court will say, but this agreement is not valid anymore. It's already discharged. Are you all getting me? So whenever there is an alteration or there is an novation or anything new is entered into a contract, there has to be an agreement from everybody. But once you have agreed to this new thing or to this alteration, then you cannot say that, no, now I had agreed, but now I don't want to go on. That will not be valid. You will have to then discharge your part of the duty. Okay. We're speaking about discharge of contract or concluding of contract. We spoke about discharge by performance. We are now speaking about discharge of contract by substituted agreements. And so we spoke about novation. We spoke about alteration. The next is, it's not about substituted agreement, but it is about cancellation of agreement, rescission. It could be cancelled by one party. It could be cancelled by both the parties. In this thing, if it is cancelled by one party, of course, the other parties will have remedies to, for whatever obligation they have discharged, to get that fulfilled from and if the other party has not fulfilled their obligation, then they'll have the privilege of going to the courts and suing them and getting some remedies. But if both the parties decide that they want to end the contract, it is rescission, cancellation of that agreement itself. Okay, and waiver, that is waiving of certain clauses from the agreement. Okay, that could be waiver that is, at some point of time. So waiver, if you look at waiver could also be a sort of an alteration itself. Okay, I had said that that 15% I want a hike on chartering. When I'm chartering my ship to you, I want a 15% hike every year. But unfortunately, because of pandemic, I'm seeing that the business is not doing so well. And so I'm waiving that 15% of hike, and I'm saying that, okay, whatever rent you have been paying, or you can pay me for the next 3 years, you pay me that rent, we will see after that. Okay. Now, in case of waiver, but any of these, no, in any of these, if both the parties do not agree with whatever has been incorporated in the agreement, what was there? The agreement was there when the agreement was signed on the 1st of January 2020. And now, today we are on the 18th of July 2021. If any change is made, if all the parties who had signed that agreement, 2 parties, 3 parties, 5 parties, 10 parties, 100 parties, if everybody had signed, even if one party says that, no, this is not acceptable, agreeable to me, then that contract can be concluded there itself. Okay. Discharge of the contract by lapse of time. The contract was for 3 years. I had given you the ship for 3 years. 3 years and 1 day, the contract is discharged, concluded. Unless you have entered into a contract to renew this contract itself. Then it will hold good. Otherwise, lapse of time, contract is discharged, concluded. Discharge by operation of law. Death of any of the person in the contract will conclude. Insolvency of any of the person in the contract will conclude. Okay. Discharge by impossibility of performance. Doctrine of frustration. Doctrine of frustration is another word or another name for when a particular act cannot be performed or cannot happen. There is this famous case study, Krell versus Henry, in which Krell had given, King Edward or someone. I just can't remember the names now, but somebody's coronation. I don't see. Okay, anyways. Have been seen from Krell's balcony very well. Okay, and so there was an agreement between the parties, and what Krell would give Henry his flat for 2 days. His balcony for flat for 2 days, and he would be able to see the coronation part was not mentioned in the agreement. Okay, it was just said that for 2 days on particular days and all that it was mentioned. And it so happened that the king take place on that day because the king, now it didn't happen on that day, but yet there was this thing of the event. It was impossible to perform that event, or whatever was there in the agreement. They had to. The coronation was going to happen on a previous day, after a few days, and Henry was then telling Krell that you had agreed to give me the thing on for the coronation, so now you have to give it to me on that particular day also, when the coronation is actually going to happen. But Krell said that no, we had agreed on these 2 days. Perhaps he had already. No, I cannot give you this kind of thing. This entire agreement or this contract between the two of them was discharged because of impossibility of performance on that particular day. Now so the court also said that the contract cannot go to a further date. This particular contract stands concluded because the event did not happen on that day. then there is discharge by breach, where one party does not fulfill, one or more parties do not fulfill their obligations. Okay, I was supposed to pay money to you because you have given me your car. Okay, I'm not paying you the money. Or you have not given me the car, I have given you the money. So I have the right to take back my money. And because the car is not there, because you have breached, or I have breached, one of us have breached. And because of the breach, the agreement is concluded. Yes. Insolvency is where the assets are less and the liability is more. Discharged by insolvency. Understood? Insolvency, where people are not in the position to pay. No, their liabilities are more than their assets. Even after selling their assets, they're not able to actually fulfill their liability. That is when a person is declared insolvent. Now, there is a separate law of insolvency altogether. Okay? So there are a lot of things that are involved in that. So of course, when discharge by insolvency will happen, Contract Act will come into picture, but also law of insolvency will come into picture. Okay, there could be a law of sick industries that would come into picture. There would be a lot of other things that would also come into picture. Okay, holistically, when you have to look at it, it will not just be restricted to this. Okay, so discharge by breach is when one party is not fulfilling the obligation, or when sometimes even both the parties are not fulfilling their obligation, so the agreement is concluded. Now, if you see over here, it is actual breach and anticipatory breach. Now, what happens is an agreement is entered into on a particular date. Okay, and an agreement actually, the contract, the performance actually starts on a later date. Okay, so on 1st of January 2021, agreement was entered that I will give my ship to you on charter. Okay, and when I will give my ship to you on charter was 1st July 2021. Okay, so the date of the agreement was 1st January. Date of the from when the performance would start was 1st of July. So what happens in between? Is the agreement there or not there? Is the contract valid or not valid? Yes, it is valid. Okay, contract comes into play on the day when it is entered in. Okay, so if on the 1st of March, if I tell you that no, I'm not giving you my vessel on charter, I have breached my word of contract or my obligation of contract. I have breached, and I will then become liable to pay you whatever damages or whatever that we will see later when we are doing the remedies. Okay, but I have breached the contract. I cannot say that, but it was going to start from the 1st of July. So how have I breached? I have breached because on 1st of January, I have entered into a contract. This is known as anticipatory breach. Okay. And if I do it after the 1st of July, I keep delaying it, or I don't send my ship, or I don't allow them to take charge of my ship, then that is an actual breach. But in both the cases, I have default. Got it? Let us quickly look at one more topic, that is the end of the law of contract by itself, and then we will start with the special contracts. Let us look at this and then take a break. Okay. Remedies for breach of contract. We saw breach of contract. Last, discharge by breach of contract. It can be actual breach or it can be anticipatory breach. So what is a breach? When one party or when both the parties are not fulfilling their obligations, that is known as a breach of contract. Okay. So remedies for breach of contract. What are the remedies? Suit for rescission of the contract. That is, when you say remedies for breach of contract, these are remedies that the court will give you. Okay. So for that, first you will have to file a suit in the court. Okay. Now, when you file a suit in the court will go. Now there are 100 things for this also. Now, what is the jurisdiction in which you will file the court? That it starts from there. So, okay, you have found the proper jurisdiction. You have filed it. Now, who's the judge before whom your matter will come? That's another thing. Now, the matter will come to a particular judge. Then, there is everything from the admission stage to the final hearing stage. In between, you take some injunctions. You take all those things are there. There are a lot of things that happen. Okay. So once the suit has been filed in the court, what are the remedies that can be asked for, and what are the remedies that the court can grant or use? So one remedy that you can ask for is suit for rescission of the contract. I do not want to go ahead with this contract. I want to terminate this contract yourself. Okay, he is not fulfilling his obligation. I don't want to go ahead with the contract. I want to terminate the contract. So that is one prayer that you can ask for in your suit. The other prayer that you can ask for is damages. He was supposed to do this as his obligation. He has not done this as his obligation. Now I have incurred a loss of so and so and so and so and so and rupees. I want damages for that amount. Contract. He had said that the vessel will arrive on the port on 1st of July 2021. I had goods that are perishable. It has arrived on the port on 10th of July. I want damages for this. Suit for quantum merit. What is quantum merit? Proportion of what has been done. Okay, the sail has gone to some port in Russia, and it was supposed to go to some port in Canada or whatever other country, assuming. Okay. The ship has reached Russia now. For some reasons, the ship cannot go further to Canada. Okay, now the person is saying that I cannot pay. I'm not going to pay because the ship was supposed to come to Canada, but it has gone. The owner of the ship can say that at least give me the money. I will load it into another ship and I will send it to you, or you look at that. But for sailing the goods from Mumbai or some port in Mumbai to the port in Mumbai. Performance is done, at least that. Suit for specific performance. I want the goods to be the specific performance. Why did I enter into an agreement? My goods are shipped to the port in Canada where my consignment. Russia, that's not my problem. You have to see to it that somehow that's specific performance. And very often for specific performance things, there are matters that are filed urgently in. Then there is something known as suit for injunction. We have heard of stay orders. Building not to be broken. Auction not to be done. Auction not to be done. Suit for injunction. These are, suit for injunctions that hold the auction, stay the auction, stay the buildings to be broken. The port will have goods. Somebody is not paid. Now these goods, what will the port do with all the goods that are accumulated? People are not paying them on time. People are not doing. So the port announces auction of the goods. Somebody comes and stays that auction. That no, we have not paid for falana reasons. We have the intentions to pay, but the port is charging us much more than what it should be charging us. So that is the reason why we are not paying. So please do not do not allow the auction to happen by the port. Please do not allow the ship to be sold. So these are all, stay orders that are granted by the court. So these are some of the breaches, some of the remedies that are available to a person who has been breached. That can somebody who towards whom breach has happened, can that person only ask for one remedy? No, he can ask for all of the remedies at one time. But specific performance and injunction and all, there has to be a logic when you're asking. Okay, so you can ask for rescission of contract. I want to terminate the contract, but I want the damages. I will not leave the damages. Now you cannot say I want a rescission of contract and specific performance. That will not happen. Okay, but you're cancelling the contract, but you want the damages. You want quantum merit. That can happen. You want specific performance and you want damages and you want quantum merit. That can happen. You want injunction. You want damages. You want quantum merit. That can happen. There has to be some logic what you're asking for. But yes, these are the remedies that are available to any person who has been deprived of the obligations that he should have been given. With this, let us take a small break and come back in 10 minutes. 47, 57. Yes.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am. Yes.
The bliss of coming and teaching in class is so much different here. You at least get a cup of coffee and glass of water. Here, everything you have to do yourself only. Okay, before we इरफान सर बुला लो क्लास में जल्दी जल्दी. अभी ये नहीं करना है यहाँ बैठे बैठे घर पे. Okay, I will share the screen, but before that I thought I should. Okay, so we spoke about the law of contract, correct? Now what we are going to do is we are going to speak about certain special contracts. Okay, now when we are going to speak about these special contracts, what are these special contracts? These are contracts which will, for which, completion or fulfillment of which all the characteristics of a valid contract will be there. But apart from those characteristics, these special contracts will have certain characteristics of their own. Okay, they will have certain characteristics of their own. And now when we are speaking about these special contracts will become more and more and more relevant to the shipping industry. Of course, they are not meant for shipping industry. They're all commercial contracts and they can be used by any industry. But yes, there would be, the shipping industry would be making more and more use of these special contracts. Okay, so when we speak about special contracts, we're going to speak about contract of indemnity, contract of guarantee, contract of agency, contract of bailment, contract of pledge. Okay, these are the 5 different contracts that we're going to speak about. So guarantee, of course, guarantee is required at different stages in any commercial transaction. There has to be somebody who's if there is any lending and borrowing that is happening, then that is where actually the guarantors come into picture. Or also in, if I'm not mistaken, in the in freight transaction and all also sometimes, there is something called a guarantee that has been issued in respect of one of the parties and all that. But typically when you speak about guarantee, it comes into picture when there is lending and borrowing that happens, and indemnity is there when you have to save somebody from the loss. And yes, saving somebody from the loss is very pertinent in the shipping industry, because you're carrying cargo from one place to another. The cargo first gets loaded at a particular port. Okay, then from the port it gets loaded to the vessel. From the vessel it again gets deloaded or unloaded on another port. So there is a possibility of this cargo also, how it is handled, how it actually stays for that much period of time of that or that duration. All that plays a very vital role. So indemnity plays, contract of indemnity comes into picture. Okay, then I spoke about agency. So when we speak about freight and all, there are mainly all this happens on agency basis. The consignor will not go to the vessel owner directly and say, dump the goods and say that this is my consignment, you go and please put it on another port. So there are agents who are doing these activities. So agency is something that definitely plays a role in the entire shipping business. Bailment. When we are going to look at speak about bailment, we will definitely do. But bailment is about transferring the goods from one person to another person for a particular purpose, and then retransferring the goods once the purpose is done with. Okay, so in shipping, what are we doing? The consignor is transferring the goods to the agent. The agent is transferring goods to the vessel owner. The vessel owner is transferring the goods to the port, where the port is transferring the goods to the consignee. So the bailment activity is continuously happening. So the contract of bailment plays a role over there. Pledging, of course, hypothecation of ships, vessels, certain machineries and all that. So pledge is also another type of contract. Pledge is very similar to bailment. Pledge basically is a special type of bailment. So we're going to look at all of that in detail. So that's a different story. But I just wanted to give you this gist in order that even if there are commercial, even if there are local non-shipping examples that come in the way, just to make things very simple to understand, you can start correlating all these activities with your shipping industry activities. Some of you all, like I saw last time, I had asked you to give me your introduction. Most of you all are from the shipping industry and worked in the shipping industry. So definitely for you all, it will be easier to understand. But there are certain people who I also know are freshers and who want to get into the shipping industry, but have not really, they still do not have a flavor of the shipping industry. But all that they have is the knowledge that they are accumulating from the lectures that are happening. And today I believe must be some 7th or 8th lecture for you guys of the shipping. So they must have not, people who are fresh, you must have these, shipping industry terms must have not really synced in yet. Does not matter. Don't really worry about that. Try and understand the concept, grasp the concept. Later on, we can do the application of that to the shipping industry or the shipping business per se. Okay, so we are going to start with the contract of indemnity. And like I said, when I was speaking about coercion and all, I said, for coercion, you can just put threat, is equal to threat. For undue influence, you can put relationship is equal, which makes it simpler or easier for you to remember in your examination. So likewise, we can also do a similar thing when we are going to speak about these various special or specific contracts. Okay, so we're going to start with the contract of indemnity, and if time permits, we will do indemnity and guarantee today, and then in the next class we will do bailment, pledge, agency, and of course, yes, we also want to do something more. Let's see. The next class we will see. Let us start with the contract of indemnity. So to put it in a very simple language, when you speak about indemnity, it is all about saving somebody from the loss that can happen to that person or the loss that can occur. It is basically about loss and saving somebody from the loss that can occur. Very simple example of indemnity. Insurance. What happens in insurance? In insurance, basically, why are you playing? What is the contract between you and the insurance company? It is that if any kind of a loss happens to you, so let us look at a specific thing like a mediclaim. Okay, so there's a loss of health. Okay, not loss of life here, but loss of health. And if you are hospitalized, the if you have a mediclaim policy, the company, ma'am, PPT screen is not visible. Sir, PPT screen is not yet shared. When I will share it, you will be able to see it. I said, I'm just doing the initial briefing, so I at least, if I can't see your faces, I can at least see your names and I feel good. Otherwise, I feel I'm speaking to the walls. So that's why I have not shared the screen yet. So, yeah, we were speaking about the insurance company. So the insurance company, it basically tells you that, okay, if you have a loss in health, if you fall ill, and if you have to incur, if you fall ill and if you are hospitalized, you have to incur a lot of cost, right? What the insurance company says is that they will make good that loss for you and they reimburse the amount that you have paid for your hospitalization, for your medication and all that. Of course, there are various clauses that this indemnity comes with, and sometimes you see, irrespective of your policy being of a certain amount, you hardly get about 50% and 60%, and that is reimbursed, and the rest of it you have to pay from your pocket. But this mediclaim policy is one of the contracts of indemnity, and likewise insurance policy on the whole. And when we speak about the shipping industry, insurance plays a very, very important role in the entire shipping business, because for obvious reasons, we know that the ships have to be insured, the cargo has to be insured, people who are traveling on the ship has to be insured. So there are a lot of things, a lot of these things that have to be insured, which is somebody has to indemnify that if there is a loss that happens, we will make good the loss for you. Okay. So insurance is not the only business that falls in any contract of indemnity. There are many other things or many other transactions that also fall in the ambit or the purview of indemnity. But just to give you a very simple example, so that you can start correlating as to what it is. Okay, so that is what indemnity is. Now, another very important thing which I will also mention about when we will be discussing about examination, because ultimately that is why we are all here, right? We are attending to this lectures because we want 75% of attendance so that we get to appear for the examination, and we are attending to this lecture and listening carefully. Are we going to get any tips, small or see? I've also been on that side of the table for a very long time, so I can associate with this. There is absolutely no harm, and that's the reason why I feel it is good to give the small tips right from the beginning, so that it doesn't come as a surprise to you at the end of the curriculum. So when I'm going to speak about indemnity, or when we are going to speak about guarantee or bailment and all, you will have to start associating when you're writing your answers in the examination. You will have to start associating it also with the shipping background or the shipping laws and acts that we are going to learn about further in the same in our curriculum now. Okay, so we're going to learn about the Indian Ports Act. We're going to learn about the Major Ports Act. We're going to learn about freight. We're going to learn about all those things. So somewhere, you will have to start correlating these things. And when you're writing your paper, you will have to start, writing about those also. You'll have to give a lot of examples. Also, another thing, I always wonder whether I should be vocal about certain things, but I really wanted to be very vocal about this one thing. Examinations are happening online, and we all know how examinations are happening, how people are writing their papers. Everybody knows. It is not a hidden fact. I have, ever since the lockdown that has happened, I have corrected from your own institute. I have corrected three sets of papers. have from the other institutes have corrected that many sets of paper and all of that within the span of 1.5 years. So it is very, very easy, and it can be very tempting also to keep your book right in front of you and copy from there. Now, what I am going to look when I am going to assist paper is that how that correlation has happened, how examples have come, how you have correlated one chapter in the book to another chapter in the book. These are some of the things that I am going to look at. I am not going to the questions will be very simple. Define indemnity and tell me what are the rights and liabilities of an indemnifier and an indemnity holder. While I'm doing that, I want you to correlate it with the board of trustees. How they are how they play a role of an indemnifier, or how a consignee plays the role of an indemnity holder. What are the rights and liabilities that they would? I wanted to look at all that. If I'm not going to get those kind of answers, then see, it is very easy. I know it is. Then it becomes an handwriting competition, honestly speaking. And then for me, it is only like, okay, your handwriting, tumhari sari, meri sari se safed hai, so give you 2 marks more. I don't want to do that. That is not really what we are looking. We are all postgraduate students, and a lot of us are even beyond that. We have come back and we are studying after a gap. So let us be a little more, mindful about how we are answering our questions. So this is something.
Actually, I wanted to ask which supplementary book to refer as for DLP students, other than the notes provided. Which supplementary book to refer?
Supplementary books I will give you the names of the textbooks and all that you can refer to, but getting those books in this current pandemic situation is absolutely not very easy. Previously it was you could go to the library and take those books and all.
But no, not for DLP. As DLP student, DLP from we are learning distance from Delhi.
You are this thing. I will tell you the author. See, if you can lay hand on Nilima Chandiramani's book, or for that matter, see, Nilima Chandiramani would have given a lot of examples of shipping, and for shipping, I think she is given more in detail, and the curriculum is also there. Otherwise, for commercial law, I would generally, suggest an ND Kapoor or something like that. But ND Kapoor would not have shipping law. So Nilima Chandiramani's book, if you can.
Ma'am, it is not available, ma'am. I have checked. It is not available.
It is not available. It is not available. We really can't do much. If you ask me, even if you make use of this book wisely, listen to my words very carefully, wisely. That is, understanding how one is correlated with the other. How one can be. See, after all, it is all about application, correct? We speak so much about, I'm digressing from the topic, but just give me 2 or 3 minutes. I want to speak about this. We have always been the mugger kinds in our country, and we always talk about, बच्चों को सिर्फ मग करने के लिए सिखाया जाता है in school. But further also, when we become students of post-graduation, graduation, we still continue doing that. If this book, you don't have to refer to any other book. If you can refer to these 160 pages, 50 pages wisely, you're done. It's sorted. But what happens is wahi hota hai then. And the PPT will also be there. That will also be shared. You can refer to the PPT also. There would be some places there could be some additional substance that you can find probably, which may not be there in the book. If you look at these things also from the point of your examination, this is enough. Okay, you don't have to keep running around, because I know it is challenging times there. Itna nahi hota aur kahan kaun se we are becoming lawyers. This book I'll this book a little bit of internet surfing of articles, and a little bit of the PPT. I think it is absolutely fine. Absolutely fine. Okay, so don't worry about that. And don't get bogged down when I speak about examination. These are just small tips which I'm sure you will be able to incorporate them wonderfully. Don't worry about it. Okay. Let us start with the special contracts now. Special contracts are also a part of the Indian Contracts Act itself. Okay. So if you look at special contracts and if you look at the definitions, then you will look at, so when we speak of contract of indemnity, it starts with section 124. So you will wonder, this is a Naya Act, and why section 124? It should be section 1. But no, it is a continuation of the Indian Contract Act. Just that the overall concept of contract we have finished with the remedies, and now we are going to focus on contracts which have some special characteristics apart from the essentials of a valid contract. So in all these special contracts, the essentials of a valid contracts have to be there. Okay, there's no choice that those have to be there. But these are the contracts which are done for specific purposes. So why is the contract of indemnity there into existence? Why has it come into existence? Let us look at the definition, and from there we can then understand why it has come into existence. A contract of indemnity is a contract by which one party promises to save the other party from loss caused to him by the conduct of the promisor himself or the conduct of any other person. Okay, loss, saving one party from the loss, and that is because of the conduct of himself or by the conduct of some other person. That is your contract of indemnity. So what are the essentials of a contract of indemnity? In a contract of indemnity, there are two parties. Now, when you speak about two parties, who are the two parties? There is an indemnifier and there is an indemnity holder. These are the two parties. But there could be multiple indemnifiers and there could be multiple indemnity holders. Okay, so by and large, there could be two set of parties, but that does not mean that there are only two parties. Screen is not visible?
It is visible.
Right? Ma'am, please explain contract of indemnity. COI is what? Contract of indemnity. What do you mean by COI?
Yes, ma'am. Contract of indemnity.
Receivers and owners. After doing this, after explaining this, you have to explain it to me. Okay. So pay attention what it is. I want you all to give me examples of that. Okay, so when we speak about indemnifiers, there could be multiple indemnifiers, there could be multiple indemnity holders. Okay. When cargo is going in a particular vessel, there could be different people who have put their consignments, right, in the cargo. Correct? There could be different people who have put their consignments in the cargo. If the vessel holder if the vessel owner has to indemnify, then there would be many indemnity holders in that particular vessel. Correct? So there are two set of parties. When you say there are two parties, there are basically two set of parties, but these two sets could involve multiple people or multiple objects or characteristics, multiple companies. So companies also, we look at them as individuals. So multiple individuals. Okay. The contract could be expressed or an implied contract. We have seen what is an express contract, what is an implied contract. So a contract of indemnity could also be an express or an implied contract. Expressed where it is mentioned in the contract that, we will make the loss good. But implied contract would be a contract wherein it is, if somebody is doing something for someone, then if there is a loss that can be, just give me 1 minute, my boss, please. I'll just, 1 minute, I'm just shutting my video. My battery is absolutely, it didn't occur me. This may just close at any moment. It did not occur to me that it was going off. Okay. You want me to on my video, right? Okay. Sorry. Let me look at the battery status. There has to be a loss. This contract will come into existence only when the loss has happened. Like for instance, when we speak about we spoke about insurance, right? We spoke about Mediclaim and all that. When does the contract come into picture? When will you want to sue the insurance company? When you have already in Mediclaim, when you have fallen ill and now the insurance company has not given you the money, right? That is the time you will sue the person, sue the same. You have to pay your premium, but you're not paying your premium on time. At the most, the insurance company will cover you only for the premium that you have paid. Okay, but that the insurance company cannot actually come and sue you for that. What they can, when will that suing thing happen, or when will somebody drag somebody to the court, is when the loss has happened. Okay, so when the loss has happened, that is the time the indemnity holder can. So who is the indemnifier and who is the indemnity holder? Indemnifier is the person who has promised to make the loss good, and indemnity holder is the person for whom the risk of loss happening exists. The risk exists. The loss may or may not occur. So in case of consignments, whose consignments are going? It is the consignor or the consignee. So it is basically a manufacturer of goods, correct? Whose goods are getting transported by sea or by vessel from one port to another. Okay, so what is at risk? The goods are at risk. If if it has to be at risk, the goods are at risk. Okay, who can make the loss good? The indemnifier. Who is the indemnifier then in this case? In your entire life. Why is this meeting recording stopping and recording again and again? I don't understand.
There's some network issue. The connection is getting.
Okay, no problem. So that is how. So indemnifier is basically a person who is going to make the loss good, and the indemnity holder is the person whose loss, if the loss occurs, it will be made good. Okay. Who is a charterer? This term is new, as I am a fresher in shipping. Anybody would like to answer, or should I answer this question? Who is a charterer? Sometimes ships are taken.
Person who hires the ship.
Yes, somebody was saying.
When an owner hires out the use of his ship to a person or a party. then that person or party can be called
as a charterer. Ships are taken on rent for use, you know. Everybody will not have their own ship, but I wanted to get into a shipping business. I cannot buy a ship. So what will I do? I will take a ship on hire and I will run the business. Correct me if I'm wrong, huh? And I will hire the business. Now there are different kinds. You're going to see that in various other subjects. I don't want to waste my time. So that is, he is a charterer, the one who is actually now running the ship, but he's not the owner of the ship. So he has taken the ship for time basis, or it could be for a particular voyage. Okay, so different ways, or on different terms and conditions, he has actually taken the ship on hire to do that business.
for the carriage of goods.
For the carriage of goods, sometimes even for the carriage of people, no, passengers also, no.
No, not for bulk vessels, merchant vessels.
Not for merchant passengers. Basically, the owners themselves run the business, not the charterers.
I think the passengers are not allowed on a bulk or a merchant vessel.
No. I'm not speaking about passengers carrying passengers on a cargo. This thing. I'm speaking about passenger line cruises and all of those. Those also can be on charter, right? Does not necessarily have to be an owner-driven business there also.
Ma'am, I wanted to ask a question.
Yes, usually the insurance is done by the buyer of the goods, depending on the type of the contract entered. Yes, the buyer of the goods will do the insurance, but so the buyer of the good will become the indemnity holder. Okay, and indemnity holder, if the buyer of the good is an indemnity holder, that's the consignee is the indemnity holder, then in that case, there would be somebody who will be the indemnifier, right? So if he is insuring the goods, he would be definitely insuring it from the insurance company. So again, the insurance company becomes the indemnifier over there. But in certain cases, there could also be that, on personal basis, or in contracts where actual insurance and all is not involved. In that case, there could be the parties of the contract. There could be just two people who have entered into a party to the contract, and they can indemnify. So there could be a buyer and a seller, and the seller would would tell the buyer that so this is the products that I am selling, and you can buy these products. And in case if you find that the products are not suitable for your business, okay, I'm ready to take back the goods, or I am ready to pay you for the loss that you have incurred in selling in buying those goods from me. Okay, so that is also something that can actually happen. Okay. Object to be lawful. So whatever that is now, if somebody is carrying, if the cargo is being carried from one port to another port, now this and if the cargo is lost, if the cargo was not a lawful object, then this entire contract of indemnity that was there between the vessel owner and the who is it, the indemnity holder, that is the consignor or the consignee or whoever, the entire agreement will be a void agreement, because the object itself was not a lawful object. Okay, but if the object is so the object has to also be lawful in order to claim indemnity. If the indemnity holder has to claim indemnity, first and foremost, he has to show that the object was a lawful object. Now, when we are speaking about all these acts, all these laws, all these concepts, all these matters going to the court and all, one very important aspect that one has to remember is providing of evidence. Typically, the person who files the suit, the onus of proving will go on him. Now, when somebody is defending and when he is making a point to defend, then the onus of proving what he is defending is right or wrong will fall on him. So it is all about how one can provide with good evidence, how one is able to prove his point to the court, even if it is civil, or it is even if it is a civil matter. Otherwise, what happens is you will come with the conception or with the perception that evidence is only there in criminal matters, where somebody has to go as a gawai in that kathara, and say that Gita pe haath rakhkar sakshi. It's not like that. Even in civil matter, a lot of evidence has to be provided. So in civil matters, evidence could be in form of documents, datas, interactions between one another, the hard copy of the contract itself. Those are the things that will prove as evidence. Not the laws good. Laws good. Who makes the laws? LOSS laws good. Okay. It is not the laws good. Somebody has asked this question now. I don't know who's asked it. What idea you couldn't get, Mr. Sangeet? I didn't understand. Anyways.
Hello, ma'am.
If somebody can.
Am I audible?
No, you're not. Okay, so let's go ahead. Object of so the object has to be lawful, and lastly, all the essentials of a valid contract. We had looked at the essentials of a valid contract: proposal, acceptance, all of that, consideration, object, competent parties. All of that has to also be in place. Only then will the contract of indemnity be a valid contract of indemnity. For all those who have not understood, let me explain very simply once more. Contract of indemnity comes into picture when there is a risk of a person suffering from any kind of a loss. Loss is LOSS loss and not LAWS loss. Okay, it is when a person, when there is a risk that a person can suffer from loss, when there is an anticipation that there is a possibility that here a loss can occur. In that case, the contract of indemnity is entered into, but the contract of indemnity will become, what do you say, it will come into force rather. The contract of indemnity will come into force only when the loss has taken place. Okay, so that is about it, about the contract of indemnity and the essentials of the contract of indemnity. Now let us look at the rights of the promisor, the indemnified, and the indemnity holder. So the promisee or the indemnified and the indemnity holder are all one and the same person. Let me go back now and speak a little bit about the promisor and the promisee. Okay, so the indemnifier is the promisor who promises the indemnity holder, who is the promisee, that if any loss occurs, if your goods are damaged because of fire, if your house is damaged because of fire, if your car meets with an accident, if your health is, if your health suffers a loss, in this case, I will make the loss good, or I will indemnify for that loss that has happened. Okay, so indemnifier is a promisor and indemnity holder is the promisee. In this transaction, in a contract of indemnity, the indemnity holder has the rights and has the ability to actually sue the indemnifier against, if the indemnifier or the promisor has not come ahead to make the loss good if the loss has happened. That is why we are only going to speak about the rights of the promisee or the indemnified or the indemnity holder. It's one and the same person. So the different names for indemnity holder are the promisee and the indemnified. The one who's getting the privilege of being indemnified is the indemnity holder, or the one to whom promise is made is the indemnity holder. So let us look at what are the rights that the indemnified or the promisee or the indemnity holder has. As per section 125 of the Indian Contracts Act 1872, look at the act. It dates back to 1872. We've spoken about this earlier also in the last class. Okay, Of course, there are amendments that keep coming, but the nomenclature of the act generally remains the same. Okay? There are certain amendments that happen which keep coming and which come as annexures and amendments inside the act, but the name of the act remain Indian Contracts Act 1872, unless they decide to scrap this act completely and bring in a new act for the same purpose. Okay? So the following rights are available to the promisee, the indemnified indemnity holder against the promisor or the indemnifier, provided he has acted within the scope of his authority. Okay? Now, right, what is the first right? Right to recover damages paid in a suit. An indemnity holder has the right to recover from the indemnifier all damages which may be compelled to pay in any suit in respect of any matter to which the contract of indemnity applies. Okay. What happens is, the indemnifier has not fulfilled his promise. For example, the insurance company has not fulfilled this promise. I have taken health insurance. Just take this as an instance, okay? Now don't come to the conclusion this is not related to shipping. Just to make you understand, let me tell you. I have taken health insurance from a company, and this is something that all of us can relate in the given situation. Okay, I've taken health insurance from from a company, and I was admitted in the hospital for 7 days because I was going through COVID. Okay, now my insurance policy was 5 lakhs of rupees, and my bill in the hospital was 1,47,000. When I got discharged from the hospital, it was a cashless transaction that I was trying to make. So when I was getting discharged from the hospital, what I got from the insurance company was only 59,000 rupees. Okay? So I had to pay about 80,000 rupees. So that's a different story that I had to pay and all that. What I did with the hospital is a different story. But, and this is what happened real, but hypothetically, if I had to go to the court, okay, if I had to go to the court, against the insurance company for not paying me the complete amount. Of course, the insurance company will have the right to say why they have not. They would also be asked. It's not that because I went to the court, I am getting what I am getting, or what I should have got. I should have got that entire 1,47,000 or whatever it is. Okay. If I was within the scope of that agreement, then probably I would have got that entire 1,47,000 rupees. But why I did not get that 1,47,000 rupees was perhaps because because what was charged from me did not fall in the scope of the insurance policy. Okay. So I would have certainly not gone to the court, because when I looked at the bill itself, I understood that a lot of these things that are charged by the hospitals are charged twice under the name of COVID. And no insurance company is going to give me that. But if I had to go to the court and if I had to prove that I have a policy of so much rupees and my bill was so much, and look at all these charges I have paid for, and all these charges fall in the purview of the policy. Okay, then what would happen is that the indemnifier, that is the insurance company, would have to pay me the amount for that policy, one. And what they would have to do, they would also have to pay me for the recovery of damages paid in the suit. Okay, and indemnity holder has the right to recover from the indemnifier all damages which he may be compelled to pay in a suit in respect of any matter in which the contract of indemnity applies. So I would have to, if I had to make a suit, I would have to pay the what is it? I would have to pay the court fees and all those things that I would have to do if I had to do all that. All those damages that I had to pay, in order to bring this suit in action, I would get that. right to recover costs incurred in defending a suit. An indemnity holder has the right to recover from the indemnifier all costs which he may be compelled to pay in any such suit if in bringing or defending it he did not contravene the orders of the promisors and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promisor authorizes him to bring or defend a suit. I had given you an example of I was a merchant, I was a manufacturer of certain goods which a company needed as raw materials. Okay, a pharmaceutical company, for instance, needed certain kind of sugar from me from me which I was manufacturing. Okay, now I had instructed this this pharmaceutical company that this sugar is of the best quality and will be of good use for the product that you're planning to manufacture, the pharmaceutical tablets or whatever injectables or whatever you're planning to manufacture, but you have to maintain it at a particular temperature. The sugar was not maintained at a particular temperature, and whereby when it was used in that particular goods that it was meant for, the goods that were manufactured were not of the right quality. Okay. Now, in this situation, the indemnity holder, that's the buyer of the good, cannot ask for damages from me because he had not followed my instructions. Okay. Had he followed my instructions, he would have the right to come and ask for the damages that happened uh, because because I didn't provide him the right kind of sugar. He could ask for that. He could also ask for the cost for defending the suit. Okay, so damages is basically what we spoke in the first section, is basically what is the loss that he has incurred. And in the second, we are speaking about cost of defending the suit. So the damages would be paid. Definitely, damages perhaps with interest would have been paid. Okay? But not just that, he would also have the right to recover the cost of defending a suit. So the lawyer's charges, court fee charges, the traveling to and forth to the court for every hearing. An indemnity holder also has the right to recover from the indemnifier all sums which he may have paid under the terms of any compromise of such suit. The compromise was not contrary to the order of the promisor and was one which it would have been prudent for the promisee to make it in the absence of any contract of indemnity, or if the promisor authorized him to compromise the suit. Okay, if the indemnifier plans to come compromises, which means plans to settle the matter and something. No, not all matters ideally go on and on in the court. Some matters, of course, a lot of matters do go to the court, but when they go to the court, it's a long time that the entire procedure takes, and because of which people feel it is better to settle the matter outside the court also. Okay, so if there is any compromise that is happening, any settlement that is happening, then anything that the indemnity holder has paid in terms of this settlement, this compromise, he will also be eligible to ask for the amount that he has used in compromising this as a as he'll be able to recover that amount also for the indemnifier. So these are some of the rights that the indemnity holder or the indemnifier can get from the promisor. You can go to the court and ask for these damages because his loss is not made good. Defending recovery of cost for defending the court, he had to go to the court in order to get that amount.
मला जायचंय 6 वाजता.
And last but not the least, recover the sum paid for settling the matter that was there in the court. So these are some of the things. Indemnity is a smaller thing. Okay, so there was a question by someone who said that, what do you mean by home AC? This is Who's a charterer that we have? Who is a charterer? We have answered that question. Please explain contract of indemnity between charterers, shippers, receivers, owners. Yes, Sanjeev. Got any idea, any clue about contract of indemnity, sorry, between charterers and shippers and receivers and owners? Did you get any idea?
मैम जब बिल्स ऑफ लेडिंग अवेलेबल नहीं होती है
Okay.
तो फिर रिसीवर जो है वो LOI देता है, लेटर ऑफ इंडेमनिटी। रिसीवर देता है, शायद चार्टरर को देता है लेटर ऑफ इंडेमनिटी।
Why would a receiver give a letter of indemnity to the charterer?
It's the other way around. It would be the charterer.
The bills of lading, when the bills of lading not available at discharge port.
In case of flammable gases, there is a high risk of explosion.
Who is this? Who is that? Somebody is on the ship or what and listening to this lecture. Okay. So, Sanjeev, that was Sanjeev, right? Who was saying
Yes,
that the charterer, that the consignee will give the letter of indemnity to whoever. No, the consignee does not have to give the consignee is basically the indemnity holder, because the consignee's goods are at risk. Correct? The consignee's goods are at risk. Whose goods are there with the port or with the in the vessel or with the owner of the ship or the charterer or the freight and clearing agent, in whose warehouse mainly the ships the goods are.
No, ma'am. When the OBLs are not available at discharge port, to represent it to the master for the cargo delivery.
What? No, I'm not understanding you. I think you are moving a little too ahead of what has been taught in the class. But I want to hear from you what you're saying. I cannot understand.
नहीं मैम, ये इसी से रिलेटेड है। जब बीएल्स अवेलेबल नहीं होती है मास्टर को रिप्रेजेंट करने के लिए, वो बीएल्स के अगेंस्ट कार्गो डिलीवरी देता है, तो इन दैट केस रिसीवर्स लेटर ऑफ इंडेमनिटी देते हैं चार्टर को।
Okay.
चार्टर को शायद नहीं देते हैं, वो मेरे ख्याल से ओनर्स को मिलता है, जो वो फिर देन दे पास ऑन टू चार्टर।
No.
रिसीवर तो चार्टर को ही देगा और फिर चार्टर ओनर को देगा।
जो शिपर होता है वो एलओआई देता है जो कार्गो लेके जा रहा है शिपिंग लाइन को, कि उसकी शिप पे लेके जा रहा है, इफ एनी डैमेजेस ऑकर, इसलिए।
No, he's speaking about when the consignee is getting the goods, right? You're speaking about when the consignee is getting the goods, but the bill of lading is not.
Actually, letter of indemnity is issued.
On basis of what will he hand over the goods? If the goods are going in the wrong hands, then correct, Sanjeev, if I'm not mistaken, this is your point, correct? And that is the time when the person is collecting the goods, he has to give a letter of indemnity saying that in case if it is found out that the goods are not belong to me or I'm not the right person to take the goods, then I will return the goods or I will make loss for the goods that I have taken. Are you what you're trying to say, Sanjeev?
In that case which you are saying, there is a separate letter called letter of authorization. It can be called as a part of letter of indemnity. Where
what letter of, whether you call it a letter of authorization, whether you call it a letter of indemnity, we are only speaking about the purpose. We are speaking about the purpose. Okay. Now the purpose is what to indemnify. Okay. Where is Sanjeev? He's gone only. He just No,
ma'am, I am listening.
Phone फेंक कर चला गया है.
नहीं, ma'am.
Okay.
But ma'am, is it possible to take a delivery without bill of lading?
Without bill of lading. That is something we want to speak about when we are doing.
No, you. In case bills of lading are not available, that's why the receivers submit letter of indemnity to the charters, and on that basis, charter submit letter of indemnity to the owners. Then owner authorized master to deliver cargo without presentation of OBLs.
But is it possible to take a deliveries without OBLs or any kind of bill of lading?
So
हाँ
Because as per my knowledge, it is not possible as per customs rules and regulations.
नहीं, बिना बिल ऑफ लेडिंग के भी कार्गो डिलीवरी होती है, वो
No,
LOI के अगेंस्ट
I
होती
don't
है.
think so.
Hey, look at a situation. Look at a situation, exceptional situation, where the bill of lading has been for some reasons destroyed, for some reasons misplaced. Does it mean that the person is not going to get his goods at all ever?
Yeah,
So
he
that
will
time,
get
that time they ask her,
Actually,
that time they ask for the duplicate bill of lading.
Actually, it
No,
is a
no.
common
Duplicate
practice.
bill
Custom
of
never
It
asked.
is a
duplicate
nowadays.
bill of lading cannot be issued until the originals are in hand.
No, they can file the case with the police stations or any kind of law authority.
They
It is
police.
a
I
common.
think the LOI is not issued for loss of bill of lading. It is only when the bill of lading is not received at the port of
Discharge.
sometimes it goes by courier, so it is not arrived or it doesn't
Yes,
reach
yes.
in time. And vessel
And what
reaches
happens
the
if the goods are of perishable nature? How long will you wait?
So in
That
that
time
case,
they issued the RFSBL, ma'am.
the shipper will give an LOI to the the charterer or the owner of the vessel that you can give the hand over my goods to the receiver, and I will not, in case it goes to the wrong hand, I will not claim against the owner of the vessel.
So see, whatever, that's what I'm saying. Formalities, names of the documents, and everything would differ. You would call it in your shipping language letter of intent. You will call it in your shipping language something else or whatever. But what is the purpose? The purpose is to see that the goods are fallen in the right hands. If they are not fallen in the right hands, what is the next course of action? The person, if the goods are fallen into the wrong hand, the person whom actually the goods were supposed to be gone to, he has suffered a loss. So there has to be something in place, some document in place which will make this loss good. That's what I'm trying to say. Forget about the word indemnity. It's about how somebody can make the loss good of anybody who is going to suffer, who's at a risk of suffering the loss. That is the entire crux or gist of this particular matter. Now, what languages you use, what is the formality that port use, what is the formality that ports in India use, what is the formality that ports in countries use, that would be different. Of course, we are going to look at a lot of things which are related to the documents. How they have tried unifying or codifying the documents so that every port will have similar things to execute and there will be no confusion. All that we are going to see later on when we are going to see the shipping law. But as of now, when we are speaking about commercial law and when we are speaking about contract of indemnity, it is about there has to be something which can prohibit the loss that can happen. And if somebody is going to suffer that loss, how is it that we can prohibit that loss? How is it that we can make, we can see that loss is made good? Otherwise, it is very easy. If one document is not there, somebody is coming claiming, he can come and claim, with whatever, letter of authority or letter of this thing that this is the letter of authority. Such documents can be actually, duplicated, triplicated, made. Nowadays, it is very easy to make any kind of document. Okay, for a very simple example, people are asking for your COVID tests, and people are forging those COVID test certificates also and going and showing on the airport and all, and everything is covered. So of course, there are going to be certain things which will have some kind of different names and which would have different formats. What fancy people take in unmuting themselves, I don't understand. But anyways, so all those things will be there. But what is the intention that has to be seen? What is the intention? Who can indemnify whom? So when we are speaking about this indemnity and all these things, the port hold ultimately the goods are they go on a particular port, right? They land on a particular port, and from there the consignee is supposed to come and pick up those goods. So when they land in the hands of the of the port authority, over there that port becomes the indemnifier, because the goods are in his custody and he has to, of course, he also becomes We are going to look at bailment. So bailment is also something that comes into picture. But when you speak of bailment and indemnity, somewhere both these things go hand in hand, because the goods are in the position of one party, and he becomes, responsible for taking care of those goods. So indemnity is also somewhere comes into picture. We are going to have a look at all of this when we are going to do the Ports Act, the Major Ports Act, Indian Ports Act. Typically these questions of destruction of goods, loss of goods, partial destructions of goods, we're going to speak about all of that. All that is going to come into picture in that. And that is when we will start getting more clearer idea about indemnity, bailment, and all these things. And that's the reason why I said, you have to start, then that is the time when you'll have to start correlating. Yes, we learned about indemnity. So how indemnity will come to picture over here? Don't get into, see, all these documents and all that you all are speaking about. I'm sure you all are going to learn that in Hajar other subjects that you all are going to do over the two times. There could be an insurance as a subject altogether for you all, perhaps. I don't know. I don't know your syllabus, but there could be where you will study this. But from the perspective of law, what we are going to do and how we are going to correlate this concept of indemnity, concept of guarantee, concept of bailment with your safety of goods, the cargo, safety of passengers, and all that is something that we will be seeing when we start the shipping laws. But you have to understand, for that you have to at least understand that yes, there is something which speaks about making the loss. Again, I'm repeating for the benefit of everyone, LOSS loss, not LAWS loss. Okay, where the loss, where there's a risk of the loss happening, that loss has to be made good by somebody. So who will make that loss good? Is there anybody responsible who should make that loss good, or there is no necessity of making that loss good? That's also another thing. Not necessary in every transaction that you do, every contract you entered into, loss has to be made good. Not necessary. But typically when you're speaking about, cargo to the tune of lakhs of rupees, see, nobody is going to put 100 rupees ka cargo and send, no. When they're sending goods, it's worth lakhs and sometimes even crores of rupees, right? So when they're putting that lakhs and crores of rupees, they have to insure it somewhere, correct? Most of the times it's the insurance company who takes the risk of getting these insured, or there are these PNI clubs and all. You all will be learning about the PNI clubs and all also. I don't want to get into that detail because then it will become another subject only will start flowing over here. But yes, second year in law, PNI clubs and all are discussed in a little more in detail when you're going to do the law of sea transport. In the second year, you have the law of sea transport. That is where all these things that we are speaking about just now, they will come a little more in detail. But till then, I'm sure you have learned about these documents and learned about these things. Do not get confused. Each organizations would have different ways of treating these kind of issues. Each ports and the port officers may have different ways and different things of treating these kind of issues. Of course, there has to be something that is in common, and that would certainly be there. But don't get bogged down by what is the name that is used and all. Understand the concept, that is, loss has to be made good, and there has to be somebody who is responsible for making this loss good, who will be an indemnifier. And if there is somebody who is responsible for making this loss good, then the indemnity holder, what is the benefits or what are the rights that this person has? He will have the rights only which are in the scope of that contract and not any other rights. That's something that is really important. Okay. Should we end the class with this? It's five almost. Okay. I'm sure we will be meeting after another 1.5 to 2 months. So let me make a note of where we have done indemnity. So we have to start with, request you all also to please make a note. We have to start with guarantee next time. Okay, just in case if I forget, remember that.
Actually, ma'am, wanted to ask, ma'am, actually, I'm not able to view your first lecture. I've been given the link, but I'm not able to view. So I also forwarded you.
That is
the
not in my. That is not in my control. I don't
no,
know.
ma'am, but it was requiring access. So I just forwarded you a message also so that you can give the it was the link was requiring an approval from your end, I think.
From my end, no. From college's end.
Okay.
No, brother, that for that you can contact with the I think the some ma'am is there and IT
Okay.
person is there, because
Okay.
the same thing has happened with me. I'm also a new admission for, and this is my first lecture. So you can check with the that ma'am.
Can I speak something? Can I say something?
Yes, ma'am. Please.
Because I was saying something and then this thing. So yes, so for this purpose, I only delivered lectures. The recording is not in my hands. It is the institute that is recording, and there is Irfan sir who can help you with getting these recordings, getting access to these recordings. Okay, so get in touch with Mr. Irfan from NMIS, who sits at the head office in Mumbai. He will give you the access to this.
Yeah, madam,
I don't.
I'll send him the link. Rahul call. Whoever find difficulty, we certainly send them the link again. Anyway, I'll send it back again. And also, if you need whenever some reminder next time when madam I'm talking to, I'm addressing to you. If you need some help regarding the last topic, I'll play that lecture for you. In case if you want that topic that is ended this lecture.
No, I try to make a note, so that I don't have to bother you guys again. I will make a note. That is not a problem. But yes, sometimes with old age, if that happens, then please help me.
Sure, anytime, madam. Sure.
Yeah. Okay. Okay. Thank you so much.
Thank you.
Bye bye. Thank you. Have a lovely weekend and have a lovely evening.
Same to you, ma'am.
Thank you, ma'am. Take care.
Thank you.